where she's responsible for automatische advies, automatic advice. She has a lot of experience as well in, actually with this Magda platform, they try to enable Flemish administration and local authorities to automate and optimize any of their processes involving data and business logic. And she was explicitly mentioned that she's very happy to be here today to elaborate on this topic of legal tech. In sum, I think I have said enough. We have 4 exciting speakers. The majority joins online, which is very happy. So please drop all the questions you may have online on clarities. Please challenge the speakers as well. I hope online everything is working now, because I got the message that someone cannot hear it, but I think the technology, and if there's problems, we have legal tech scholars, practitioners here that can for sure help me as a poor moderator of this debate. I will first give the floor to maybe, I don't know, Annelies, because she has a presentation, and then we go, yes, and I see that got the online confirmation that it works. So Annelies, the floor is yours, and please, the audience, spicy up the questions in the chat. We have prepared several as well, but it would of course be way more interesting to have your views on this topic of legal tech.
I hope the sound is okay. Otherwise, I will hear it, and so it's not okay. Yes. First of all, good afternoon, everybody, and thank you. I would say thank you to Thomas and to Jan and everybody from the organization for the invitation. It's really an honor to be invited to this panel discussion in such a good company. So allow me to introduce myself. My name is Annelies van der Wooydonks, and I work as a product owner with Digital Vlaanderen, so Digital Flanders, and more specifically, I hold the product of automatische advies, so to say automatic advice in my product portfolio. So that's what I'm going to talk about today, about automatische advies, otherwise it will be too extensive. First of all, automatische advies in the first place gets access to data from authentic data sources using the Magda platform. Magda is really short for maximum data sharing between administrations, and that is our main focus within Magda. We try to facilitate the use and the sharing of government data between administrations, given the right authorizations are, of course, in place. Now, automatische advies goes one step further. It does not only gather and collect this data, but it also puts an extra layer of business logic, of business intelligence on top of the data at stake. So not only share data, but also deliver an interpretation of the data or deliver an advice with respect to the data. In that way, we try to enable Flemish and local governments to automate and optimize any of their processes that involve data of business intelligence. Now, I provided for a small example and very straightforward, just to give you a bit of an insight how it works in practice. So let's say that we have the city of Leuven and they want to grant allowances to people, provided that certain conditions are met. Let's say you have to live in Leuven, you have to be older than 18 years old, and your wage may not exceed a certain threshold. So very, very straightforward. We will then receive an incoming request, so that's quite technical. We will receive an incoming call from the city of Leuven with the national identification number of person X, with the question, could you please verify whether this person is eligible for the allowance, yes or no? We will then use this national identification number to, in a second stage, gather all the relevant data from authentic data sources. And that's when Magda comes into play. We use the Magda platform as a very safe platform to share data, to collect all data. So we collect all this data relevant for person X, relevant for the case at hand. And then we will render an advice based on business intelligence. So we will apply business logic to the data that we collected in stage 2. This business intelligence is in the form of business rules that we program. I don't program it because I'm not technical, but we program it in a business rule engine of IBM ODM. That's a USA company, and we use that as a SaaS. So that's a bit the framework of automatische advies. And then when we validated all these business rules, so like for example, in the example that I have given, we will need to check the address of the person X, and we will need to check is this within the territory of Leuven. We will need to apply certain business logic to see if its birth date, if it's older than 18 years old or younger than 18 years old. It's very, very straightforward. It is a lot more complicated in practice, but it's just to give you an idea how that works. Then we will render an advice to the city of Leuven. So we really say we think based on the facts that we think that person X is eligible for the allowance or is not eligible for the allowance. And we will also give the outcome of the different parameters individually. So we will say person X is not eligible because he doesn't live in Leuven or he is younger than 18 years old. So we also make a difference or break down why he is or is not eligible. And last but not least, we can also send through the authentic data contributing to the advice if, again, the city of Leuven is authorized to receive this data and to allow them, in fact, to make the final decision what to do with the data and with the advice. So that was really, really in a nutshell how Automatisch Advies works together with Magda. So which challenges do we face today, or did we face while setting up Automatisch Advies in 2018? So it's quite a young product. Of course, when we say data, we say GDPR. I'm in good company with all the experts of GDPR and intellectual property law. But maybe the ones who have paying close attention also note that that I said that we use IBM ODM, an American company, USA company, to render our business intelligence, and that brings us into the scope of Schrems 2. So again, I have a lot of experts here about Schrems 2. So that's an important thing to know. We are aware of this, of these challenges, and that's maybe also the first point I wanted to start it with. We are aware that processing data and personal data, of course, is bringing risks to the table, and we are continuously monitoring our way of working, and we are continuously monitoring or assessing whether our mitigating measures that we have put in place, whether they are adequate in the light of changing case law, in the light of changing regulation. So that's maybe the first thing I wanted to kick off with. And now maybe I will deep dive into the mitigating measures that are in place. So a very strong safeguard that we have built is that no personal data whatsoever is sent to the business rule engine. That may sound a bit odd because we need data in the business rule engine to validate these business rules. But you will see in practice, and I will give an example in a minute, that it's typically no data that could uniquely identify a person or an individual. That data is not the data that has to be sent to the business rule engine. That is not the data that has to be validated against business rules. If you take the example of the city of Leuven, I said we need to verify whether the person X lives in Leuven, but to do so, we are not going to send the whole and exact address of the person concerned to the business rule engine. We're only going to send the postal code. So in that way, we can validate the business rule is a person residing within the territory of Leuven or not, but we don't need the exact and the whole address of the person concerned. The same with the national identification number. I said before, we use the national identification number to gather all the data from the relevant and authentic data sources, but the national identification number itself is not going to be sent to the business rule engine, because you can imagine it would not be, it would quite be discriminatory to say your national number has to end with a 1 and then you come into the scope of the allowance. So the number itself is not a parameter, it's not something that needs to be validated in the business rule engine. So I hope that's clear to you. Another one maybe is the fact that we don't store any data. So there is a complete absence of data storage. We only have a temporary storage of 8 hours to make our product, to make it work, of course. But we work with Automatisch Advies only with transactional data. That means that if we receive an incoming request from the city of Leuven, we will then launch ad hoc requests to all the different authentic data sources to gather all the data that is relevant and necessary for the case at hand. But the moment that we collected all the data and the moment that we rendered our advice to the city of Leuven, we will delete everything. So we delete the data processed of gathered during the process, and we will also delete the outcome of the advice. So everything is deleted. of course, after being sent to the city of Leuven. Otherwise, it would be quite a shame. That's are the two main safeguards I think we have with automatisch advies. Then another one that is important to highlight to you is that we require from all our software suppliers that data centers are located in Europe. So also for IBM ODM, they're located in France and Germany. And last general remark is maybe that it's not the purpose of automatisch advies to automate decisions with a direct binding legal effect. So it's more, we want to give a recommendation to our end users to say, we think that person X is eligible for the allowance, or we think he is not eligible for the allowance, but it's still up to the end user to make a final decision and to decide which consequences to attach to this advice. So that was about automatisch advies and Magda, and more in general what we have now. Maybe it's other interesting topic is that we talked about automatisch advies, we talked about Magda in a super tempo, I'm aware, but that's all about sharing data and sharing interpretations of data. And what we're really trying to do next is to create more data insights to support Flemish and local governments in their policy making. And to do so, we will try to implement AI, artificial intelligence, and analytics. But one very major challenge that we will face when elaborating this option is that we need to access complete data sets, including historical data, because otherwise you cannot apply machine learning and you cannot apply simulations. Instead of the transactional ad hoc data extracts we use today for automatisch advies. So that will really bring to the table another challenge. And yes, we are eager to see what the future holds for that one. So that was it from my part. I hope this was a bit clear to everybody of you. Of course, please feel free to reach out to me by scanning the QR code on the slide through LinkedIn, or if you want to keep in touch, you can always send me an email or contact me via other ways.
Thank you, Annelies, for this very interesting presentation. And also, I think we all are very excited for the future, whatever comes up on the technological perspectives. So for the audience, we have the government, the Flemish government perspective, maybe not perspective as such, but more the view of how the Flemish government is also on this digital train, what is going on and so forth. So again, please, if you would have questions for Annelies, drop them in the chat. I think she already mentioned a lot of interesting thoughts on mitigating risks, how to deal with data, the risk of personal data and GDPR related issues. So please feel free to drop the questions that you may have also to the audience in the room. Again, raise your hand if you would like to drop something. I would propose that we go to the next speaker sitting on the right of Annelies. Senne, the floor is yours. I already briefly introduced you, but please go ahead and tell us about the fantastic activities you do with your tech startup.
Yeah, thank you very much. Welcome everyone. Thank you so much for being here. My name is Senne. I am a former lawyer and co-founder of Clausebase. To give a little bit of background, so I studied here at KU Leuven, did an additional specialization year at the University of King's College London, and then I started at DLA Piper as a junior associate specializing in intellectual property and technology law. A large part of what I did there was legal drafting, be it in contract form, be it legal advice, being litigation documents like petitions to the court and things like that. And what I found was that there is a huge amount of reproduction work being done. There's a huge amount of reinventing the wheel each time you draft. The legal drafting process is kind of like an arts and crafts project, as I like to compare it to. You always start, and again, be it contracts, be it legal advice, there's always this sort of central way of working. You always start from a precedent, and then you start sort of copying and pasting different parts of different documents into your precedent document, and you arrive at this sort of amalgamation of different content from different sources and things like that. And it's a very time-consuming process, a very labor-intensive process. And the worst part of it is that every single lawyer has to go through this process pretty much by themselves. I mean, of course, you can start talking to senior associates and ask them for help in retrieving the right content. And that's also, of course, a huge part of the equation is finding the right content when you're drafting legal documents. But an even larger and oftentimes more infuriating part is cleaning that content up and kind of engaging, as I like to call it, the battle with Microsoft Word. And that's kind of where Clausebase as an idea came from. Clausebase was created by two former attorneys, both with, so including myself, of course, both with legal drafting experience. And we wanted to, we were essentially already involved with some of the tech initiatives in the firm, and we weren't really happy with what we were seeing out there on the market in terms of legal drafting software. And so our approach with Clausebase has always been very much central to that arts and crafts project. And we've always tried to really meet lawyers in optimizing that arts and crafts project, optimizing the way that they make their content available, the way that they store that knowledge that they've created over the years that they've been active in better ways, and to also help new joiners in the organization, help them make the most of that knowledge. And in a nutshell, how Clausebase works is you essentially, when you start using the platform, you essentially have an empty box, so to speak. The Clausebase offers a variety of tools to create what we call a clause library. So a library of different blocks of text, clauses that you can augment with all kinds of intelligence. So think, for example, let's say that you take a clause from one document and paste it into another. Chances are you'll have to clean up a lot of things like numbering, like styling, like terminology, some legal nuance perhaps. Maybe the document that you created previously where you drew your clause from, maybe you were acting for the client and now you're acting for the supplier, and there's all sorts of different commercial positions, all sorts of different legal positions that you have to take into account. And so Clausebase allows you to augment these clauses to make them more than just static pieces of text, and allow you to really focus your drafting efforts on finding that clause, deploying it fairly easily, and sort of shifting that balance back from the production work that you have to spend, all that time that you have to spend on just battling Microsoft Word, finding that content, cleaning it up, etc., and refocusing it more towards the legal efforts. And so in Clausebase, you have that collection of clauses in a library. There's then two ways that you can go about actually using that knowledge, those clauses in practice. One way is to create bespoke documents by essentially stacking those clauses on top of each other, kind of like legal building blocks or legal puzzle pieces, if you will. And Clausebase ensures the consistency and coherence of both the style and the content, so that you don't have to spend too much time doing that kind of work. That's one way that you can approach the drafting process via Clausebase. Another way is that you can create templates in that way with all sorts of augmented clauses capable of switching their nuance at the click of a button, capable of switching their terminology and then numbering, etc. And then essentially transforming those templates into a list of questions and that you can just start filling out to essentially arrive at a fully automated document on the basis of an underlying template, really. And now we also recently launched a product expansion that allows you to gain access to that library of intelligent clauses. We also sometimes call them chameleon clauses because they kind of adapt to the environment that they are placed in. And so essentially it gives you access to that library directly from within Microsoft Word as a sort of Microsoft Word plugin. What we found was that Clausebase was an ideal tool for creating first drafts, but of course the document creation process is more than just generating a first draft. There's all sorts of negotiation phases and feedback and things like that. And so with our new product expansion, we were also seeking to cover that line of legal work where you move beyond that initial first draft. And that's me and Clausebase in a nutshell.
Okay, so thank you very much to elaborate on yourself and on Clausebase, which is of course very very fascinating to hear. especially I assume that all of us know as legal scholars are aware of like the many hurdles when all these reading and all these clauses. So fantastic that this is going on. I'm quite sure, I for sure have several questions, but I'm quite sure the audience may have some as well. We will come back to that later. The third speaker, yet another perspective, the perspective of the notaries. We have Jan Sap, as I mentioned, the director of FedNot, previously at Unizo, and now I'm correct. No, I'm quite sure that you also have a lot of interesting things to say, because at FedNot, there's a lot of people working on IT as well, to really make these transactions in the notarial sector working. So Mr. Sap, the floor is yours, and thanks again for being here.
Thank you for having me. Good afternoon, everybody. We are, as you said, really into digitalization. It's not very known, but the notary sector is one of the most digitalized sectors, I think, in all a lot of other sectors I have been working in. Maybe a bit situate the federation. We're rather a typical federation. We have 200 people working on the federation, on which the half, so 100 people are working on IT applications for the notary. So we're really a service hub, you could say, for IT for the notaries, and that makes us typical in the world of the federation. We are one of the federation who's really into digitalization, into IT. And that's because the notaries found it important to, let's say, bring their money and their efforts together within the federation and stimulate also digitalization on a collective basis, so within a federation. We've been working on digitalization. We started in the year 2000, and there are, you could say, 3 waves in our digital evolution in the notary sector. The first wave was that we created a network between the federation and the notaries, and between the notaries also, and a digital network. And that was very important. It's still very important. So we created a platform, e-notariat, is it called now, on which all notaries and all the employees of the notaries, we're talking about 10,000 people in global in the notary sector, are using it day to day. So everybody works now on the e-notariat, on the notary platform, and all the IT application which notaries need to do their job, to do their business, is on that central platform. That's the first wave on which we work. The second wave, digital wave, was creating communication, creating lines with the public authorities and the notaries. We work a lot with a lot of administration, Flanders also, but we work also with the federal authorities, fiscal authorities. So we created digital tunnels between the notary and the different public authorities. We started, for example, with eDepot. That's a way to create a company. You need some authorities to fill in some forms. So we did a digitalization of that kind of form, so everything can know, instead of paper flow, it's now a digital flow to create a company for the notary. And the third wave is that we did some digital issues for the citizens. The most known, I think, is Bidit. Bidit is an online platform in which you can buy and sell houses, apartments in Belgium. We created it about 3 years ago. Now we have about 7,000 houses which were sold by that online platform. It's under control by a notary, but everything goes on an online way. The second example is EasyMe. That's a digital wallet we created on which you can have your authentic deed. So you can have it's a wallet on which you can store all important documents you think you have to store in the digital wallet. It's free for all Belgian citizens, but you can also have your personal, authentic, notarial deed on that digital wallet platform. So it's free for all Belgian citizens. And it's important that we also create, let's say, a digital notary for the citizens. So they can also, and that's a bit strategic, so that they also, so that they can see that the notary does not only exist in the real, but also on a digital way. I want to also stress on two projects on which we are working on now. We are working with also artificial intelligence, and glad to hear what you're doing on that way. We have a data lake with all the authentic deeds who were in a central lake who is stored within the federation. And we did an anonymization and pseudonymization of all these deeds. So it's GDPR proof. We have a battery of DPOs within the federation working, because every notary has to have a DPO for his notary study. What we did is we now are checking if we can use the different clauses on the deeds, and we can reuse them for the whole notary, for the whole notary sector. So now we're checking with artificial intelligence all the clauses who are in the different deeds, and see how they can be reused by other notaries. Second project on which is very important is that we go from a deed on paper to a digital deed. So now you don't have to, for the constitution of a new company, normally you have to go physically to a notary. Since a year, we have digitalized this whole process, so you don't have to go physically to a notary. You can do it by video conference and also by a digital platform that we created. You can fill in, the notary will also fill in the things he had to fill in, so we can create now on a digital way without going to a notary. We can process to have a deed on digital way instead of the classical way in which you have to go to the notary. And that's really an evolution. We are really going to digital deeds also, and the first step is now starting a company. We can do it on a digital way. That's in very short terms what we are doing on FedNot, on the Federation of the Notaries, on digitalization.
Okay, thank you as well for your interesting view on, and especially what FedNot is currently doing and has been doing in the past. And I know a lot of my former colleagues of Ghent do work at FedNot, and they are indeed saying the digital train could happen there, is there happening as well. So indeed, Mr. Sapp is very right to say that FedNot has been doing a lot for the sector when it comes to technology. Last but not least, we have Ms. van der Stichler. I already shortly introduced her, but she is an authority on legal tech. I think everyone in Belgium in the area, in the domain, knows her name. And so we're very happy also that you joined today. And please, the floor is yours. Thank you again.
Thank you for your kind words, and thank you for having me today. When it comes to the judiciary, I think the exercise is quite complex. Let me start with saying that the previous Minister of Justice and the current Minister of Justice have been very active. Under the previous Minister of Justice, it was under the stimulus of a notary. That a lot has been set up. At the same time, there were initiatives within the courts, mainly within the Court of Appeal of Antwerp, which was very active. Our current Minister of Justice is continuing at high speed, is involving the judiciary. Judges can have a say to a certain extent in what is going on. Quite a few judges are very active and are working very hard on everything that has to do with digitization. It remains a complex exercise, and why is that? I think we have to cover a wide range of tasks and a wide range of values. And when I talk about the tasks, you have to communicate, you have to link to all different instances, parts of society, and that varies according to the type of legal problem you have. So a juvenile court, a criminal court, a business court, they all have different links to society, different sources of data that have to come in and that have to be processed, and where normally there should be added value in the decision making. So communication and linking to parts of society is very important. And then of course you have the internal data processing. where we have e-deposit now, to name just one thing. That is not so much the focus of my research. My research is about how can we use machine learning, natural language processing to come to a decision. So a lot of what has been said before by the other speakers is quite relevant, and there are parallels. When you talk about the decision making itself, and also about online hearings and about part of the back office organization, you immediately see that different values come into play. There are different views on what a judge is, what a judge should do, what is a good judge, what is a bad judge. Often you see differences according to the type of law. For instance, in a business case between two businesses who have a problem about their contract, didn't mediate, didn't arbitrate, but come before court, they want a solution, and they're solution oriented. I think business courts should be able to cater for this type of problem, but you also have problems, legal problems and disputes, where the process to arrive at the decision and where the hearing and where the discussion among the parties is a very important part of coming to a solution. So you have to cater for all those different types of demands and expectations, and those different views on what is actually adjudication. There are a lot of initiatives worldwide. Brazil is one of the courts with a huge backlog. They have millions and millions, I've forgotten the exact figure, but millions of cases pending. So they adopted a law where they allowed the courts to take their own initiative and to develop their own machine learning and natural language processing applications. They get money for it, provided they share with other courts what they have made, and provided other courts have not solved the problem in the same way. So there are obviously optimization of the finances. It is interesting what is happening. For instance, the Supreme Court has now an automatic tool that assists in assessing whether the application that is made is respecting all formal elements that need to be met before the case can be introduced. One of the very important aspects that makes it harder for the judiciary is the question: to what extent do we want privatization? Do we want to outsource all data and all applications to private companies, or do we develop it within the government? And if you outsource it to part of the actual decision making to private companies, then you immediately see you have issues with individual privacy, group privacy, but also with your societal aspect, because mostly with most companies, the software is behind the paywall. America has had the notorious case of Compass, where there was assisted decision making to release suspects on bail or not to release on them. Judges have no access to the data set, have no access to the decision making tool, the statistics that have been applied. And then you get automation bias, or that is a risk. You get confirmation bias that, judges say, well, since the machine came with this solution, I assume it is correct and I go for it. Is that good decision making? Is that what you want in a society, especially in criminal law? I think you have to make the distinction between criminal law and civil law. So that is a real issue. If you ask private companies to exercise by part of the public competences, under what circumstances can this be done? Can this be done? And under what circumstances, if it can be done? And I will end with one thing that I think is very important and that you don't hear very much, or that you hardly hear anywhere, is that for the judiciary, what digital technologies in general that will be the case in the future with augmented and virtual reality as well, and not only with data and with so-called AI, is that it adds a layer. So your judgment, your text becomes a techno-text. The treatment of different data to exercise whatever task a judge exercises, be it legal search, be it summarization, be it extracting arguments and reflecting the arguments back to the judge who has to make a decision. The way that part is performed is something we have not learned in law school, especially not for judges who usually are a bit older, and requires different methods. So your decision making changes actually in 5 aspects, and how we have to integrate that into the court system and into society, which is more important than just the court system as a system. There is still a lot of research to be carried out, and I end on that note.
I think it's a fantastic note to end on, leading towards the Q&A that will follow. I think we had different perspective on the same topic, so I think this makes it very interesting. I already told the online audience to drop the questions, also to the audience here. If you have questions, go ahead. I will first ask here. If there are questions, if not, I have some, of course, but yes?
For yourself, about digitalization towards citizens.
Mhm.
What about citizens that are still not fully capable of entering the digital world? Because I think of my own dad, who's 84, and the whole digitalization of society went past him. So are you making sure that you will keep everyone on board with the digitalization?
I will briefly recap for the online audience as well. So the question is how to make sure that everyone is involved, every citizen in this digital train. What with those that do not have digital skills or access to online environment? So how does the FedNot and the notaries can deal with this? So this is the question that from the
Yes, it's a very interesting question. It's the question of digital inclusion. And we are also suffering with that. So we really have to take care, and it's the notary himself who have to take care of that, to see that is the person who is in front of me on a screen or not on a screen is capable to do it on a digital way. So it will always be the notary who will decide with the client if he or she will do the deed in a digital way. So we always keep the possibility to do it on the, let's say, the classical normal way, beside the digital way. But it's really something on which we are suffering. We, for example, during the COVID crisis, we had a lot of deeds on a digital way with video conferences. It was really sometimes, sorry for some older people, really a struggle to help them with their EID, for example, or it's me, they didn't know the numbers. It's really, you really need some assistance from, and it was a notary did it. It took hours sometimes to check if everything was okay. But that's really the role of the notary to see really what is possible in a digital way, yes or no. And we always keep the possibility to do it on a classical way, besides the classical digital way.
Does someone want to add from the speakers something, a thought, or?
Well, I think digital inclusion is for the judiciary obviously a challenge as well. And you will always have, but there is an initiative now in, I think, the courts of first instance, Mechelen, Antwerpen, where there is in the entrance hall assistance to access computers or to have a service, a social service that is present to help people. So you can organize in a way, as long as you have a physical building and a physical point where people still can go to. There is a possibility to also try to include everybody, but it requires attention and organization. It happens and it is possible, but catching everybody in society is always a huge challenge.
On the side note from the judiciary, not that I doubt that, but are judges also future-proof, or are they not? I mean, in a sense, because we talk about digital literacy in the sense that everyone should be included, but eventually, especially for example in tort law, my background, judges are so important to apply the law. Is there some, how do they deal with the technological evolutions, or it may be a difficult question, so
I'll give a lawyerish answer. It depends.
Okay.
So I think quite a few judges, let's say, are aware that it will require extra effort, are making extra efforts. I would not say that everybody is on that line yet. So het Instituut voor Gerechtelijke Opleiding is starting to make efforts to have the younger judges and the trainees get them on board. But the thing is also, it's a cultural thing, I think. It's not age thing, it's a cultural thing. And very often lawyers are frightened by statistics, but it's not only statistics, it's much more than statistics, because we are evolving to rule-based AI, so-called AI, and data-based AI, and the rule-based AI is quite a bit more along the way we're used to reason. So I would encourage judges and lawyers to take a look at it, but it is also a problem of attention, or an area of attention.
Okay, great, thank you.
Something that I want to add here is that sometimes you see also in day-to-day life that processes getting digitized that are becoming more complex because of the digitization doing that. So that's also something like when you apply rules-based systems or apply AI, NLP and so on, sometimes it's so complex and behind the scenes a lot is happening. But then you need to decide how you bring it in application, UI, UX, and you can do that showing everything and then it's too overwhelming, or you can do it very minimal and then it's not showing enough what is happening behind the scenes. So you really need to find a very good balance so that what you do is better. And the same with when you mitigate risks for GDPR or the Future AI Act, the same there. When you're overbuilding a process, it becomes more complicated, and then maybe it's better to do it the old way. Or maybe the paperwork is for so many years improved and becoming simple and how it should be. And when you digitize, it's overcomplicated because you didn't do enough rounds to simplify.
Yeah.
Yeah, go ahead. I'll just briefly, it's about like making things more complex because of digitalization. And so this was a bit for
you're focused on solving a problem technically, but you forget the end user.
Yes, the end user is forgotten.
The end user can be somebody who's very technical and going along. Like you can go to a Téléphone and buy your tickets completely virtually. And then you go home and you still have credits and you can't ask for a refund. They force you to go to the next Téléphone and use your tickets there. This is not a good system because it's business model probably, but it's not very transparent to the end user.
Okay.
It's a digitized way of earning money, but the old way was honest, and the new way not. And this is
I can agree with what you're saying. Certainly, we are really it's sometimes a battle between the people are on the legal persons and the IT persons within our federation. And if we just want to digitalize the paper flow, we're not doing a good thing, but because then we will overcomplex certainly the digital way to do things. I think you always have to rethink the whole process, even the paper process, before you start with your digitalization process. But that's very difficult. So we also sometimes have to change the law because we can't do it because the law says you have to do that. It's very procedure and forms and regulations. So we always have to, but that's a difficult one. We struggle between the legal persons and the IT persons to really have a good balance between what is doable, what is practical on a digital way, and what is okay on the legal way. So you have, before that, you have also to rethink the process and rethink the whole, even the law. Do we really need this form to do that? But that's
what is the problem you're solving?
And when
Yes.
you do that, then you
Sure.
have an hour and you need to fail fast like this go down. And then you again need to focus again what is the problem you're solving, but it's an iteration that goes on. And in that iteration you often lose connection to what was the
Initial problem.
start.
I'm quite sure that Annelies may have to. I'm not saying that you have to, but I see that you're about to say something, and
I was
considering your
waiting
role.
for the moment.
Well, here you go. I give you the
Thank you,
moment.
Jan. No, I really would like to join and agree with Jan on this one, because how I see it with the business rule engine, it creates also a lot of opportunities to rethink the way of working we do it now. So, for example, if we have a project running for granting an allowance, and then we see, we have to program these business rules together with the end user. So we say, okay, does he have to live in Leuven? What is his wage limit? And then we notice while we are discussing this that sometimes they don't even know it themselves why it was originally this rule or this logic. So it really creates also opportunities to rethink this and to see, okay, what is really necessary here and how can we make it lean for going forward. So it's something we also see. Yeah.
Sene, if you would like to add something, I'm quite sure you also have a lot of thoughts.
Absolutely. So I'm hearing a lot of importance rightfully being placed on the role of process in any given operation. As a bit of background, so we sell legal drafting software to parties like law firms, like in-house legal counsel, and what we find there indeed that there's often a sincere lack of focus on that process, right? And that technology is seen as this shiny, magical answer to a problem that hasn't really been, approached, or where no, effort has been made to actually solve that problem without technology or with existing tools, for example. So I completely agree. It's there's this popular saying in business, right? People, process, technology, in that order. And so as a technology vendor, I can only concur that it's crucial to first have that process in place, and that technology can only be an augmentation of that process, an improvement on that process, but that needs to be there first. The kinds of solutions that are a solution in search of a problem rarely work out.
Yes.
Very briefly, that is what Philip Eger calls a grammar of action. And so the computer, the digital technologies require you to establish a grammar, literally a grammar of action and of several steps that you need to be taken. Once that's done, the dynamic changes, and it's the grammar of action as it has been established that sets a whole process of evolution into or starts a whole new process of action. And the risk is indeed that a lot gets lost, and that a lot of the expertise or the common sense of what it was previously paper-based gets lost. So I think it will require a lot of training and a lot of attention to capture the good things about what we're doing on paper.
And if I may add, because it has been mentioned already, is the law fit to deal with these situations, or how do we, or what should be done? It has been, what can policymakers do to really take this balance into account? Because it's quite easy said, we need to have this balance between transparency, non-transparency, but how do you make this concrete?
Go ahead.
Well, I think that's why not only the judges have be up to knowledge, but our lawmakers, not only the policymakers, but the lawmakers. And the way, and you see some parliaments in the world who start to make law differently, but that will change enormously and still has to change enormously. So you don't get stuck with an existing law that determines and that blocks the evolution.
Yes.
So then this actually then would mean that we need new law, or like cancel the old ones, put very simply, to adopt new ones, or is there another risk of regulatory over regulation of certain things, or?
The main projects, BIDIT, for example, during the COVID crisis, we really had to change the law otherwise we could not digitalize some processes. It was not mentioned in the law, and it's right what you said. The lawmakers are not aware of that, not at all. It must come from or the people or the sector itself who make. We did some suggestions to the lawmakers. You have to change the law if you want to have a system like BIDIT. We really have to change the laws. Otherwise, it wouldn't be possible to make this to do this on a digital way.
If
It's from my perspective, it's a little bit difficult to kind of weigh in on policymakers, right? Because I'm mostly involved with the actual private actors who practice the law on a daily basis. But I do think that as Jan said, there's often still many kinds of statutory hurdles to practicing the law in such a way. I do think that there's quite a few things that can already be done. The primary hurdles that I see from private actors practicing law, think law firms, think in-house legal departments, on that front primarily remain. So those hurdles primarily remain commercial in nature. For example, efficiency in law firms is today not really a priority. Of course, every lawyer, every law firm wants to provide their services in as client-friendly way and as efficient a way as possible. But the reality of the situation is that there's institutions in place like the billable hour model, and so that doesn't really benefit the end user, so to speak, of the legal service, the client. Ultimately, I think improvements on that end of the spectrum can still be made regardless of the current climate in terms of statutory hurdles to legal service improvements.
I saw also someone raising his hand. Yes.
I have a question. Michel Seges, I'm a lawyer and also a member of the Inclusive Project Bar, and I had contacted Geneviève also regarding the topic that will be hot in data land, I think, with a new law that will pass to digitalize and make database all judgments of courts and court appeals. I don't know what you think this will, in Belgium only, I think 0.5% of judgments is published. Of course, it's still a long way to go to database, but how do you see this in data in the future, and how it will help, or what are maybe the dangers of this database for the future?
I think I've, at least in part, I've already touched upon that. I think if you're talking about the problems, you have the individual privacy for the people involved. Can you pseudonymize, because that's what the intended law is now, can you pseudonymize enough? Is it possible to reverse engineer and to still say, well, Mr. Such and Such had such and such a problem, and we were able to distill it from the decision. So that's the individual part. The group part is that what we see in courts is that groups of people, of type of people, have types of problems, and so you could target groups. So that's another problem. And a third problem with a completely open database. No country, by the way, has an open database. Nowhere in the world. It is filtered. And before we had the current geopolitical problems, it always has been an issue. Do you want to expose your entire business law decisions for the whole world? Do you want to expose your economy in such a way? I really, really doubt it.
Because in the draft law, the names of companies would not be pseudonymized.
And the filter is not very narrow either. So I do have questions. I do understand that scientific projects want to observe judges, and I think society has a right to observe judges. I also think they have a right to observe their notaries and private companies, but that's a different issue. Judges have a specific task in society, and it should be subject of discussion in a civilized way and not in a personal way, but that so the decision itself should be the subject of discussion. The question is, how do you go about it? And do you do that by just opening a database for the whole public? Also, I understand that private companies are really interested in having access to the whole database, obviously, for giving advice to your client. That is an interesting source. And then it comes behind the paywall, and only fortunate clients or clients who can afford it have access to the advice that is based, and then it is reused in court. That is already happening with legal search. When you enter a question, depending on who enters the question, and there's publications about that, who the person is who enters the question, the query, and how it is phrased, you just get different results. Why is that? If I get a result, have I seen everything I need to see, I want to see? Does it make me think? So you have private companies who are influencing. That's why also in the European data and the Digital Service Act and the Digital Markets Act, you should include what lawyers and what private companies do with the judicial data, and not only what the courts do with judicial data and AI, because indirectly the private sector influences the decision making. So that's a long answer, and it is not an easy answer. You have to balance different values and different objectives.
It's again about balancing, which is a word that is often coming back in this panel discussion, which I like as well, which is because it's very legalese, balancing. So I got a question from a chat, and it's closely related to another question that I had as well, and I'm quite sure that 4 of you can say something fantastic on this. Do you think that legal professionals will need to learn technical coding skills? What do you think of these profiles who combine the legal background and a programming background? And send an analysis.
Yeah,
Send it to us.
Yes.
Yeah, this is a question that pops up from time to time, especially in the legal sector, right? Do lawyers need to learn how to code? There's been oceans of ink that have flowed on that topic. The short answer is no. The long answer is it depends, you know, to give a lawyerly answer again, right? Here's the thing. A lot of people expect when they ask the question, do lawyers need to learn how to code, that lawyers will somehow be creating software applications after that. But there's so much more that comes with developing software applications than just learning how to write code. There's server hosting and things like that. There's maintenance and upgrades and things like that. There's more to developing software than just knowing how to write code. Of course, it's still a valuable skill to have, and I do have to, you know, be fully honest. The Clause Base was founded by someone who exactly has that kind of dual profile, has that vast software development expertise, and also a long career in the legal sector. And so it's really on the basis of that kind of dual knowledge that we were able to build what we have built. But I think it's important to manage your expectations when it comes to learning how to code. I think the primary benefits that can be achieved from lawyers learning how to code is sort of a brain expanding exercise. It's very helpful to learn how to code, if only to stop thinking, or to start thinking rather, in terms of not repeating yourself. One of the crucial tenets of software developers is don't repeat yourself. As lawyers, that's pretty much all we do in our career, is just repeating ourselves over and over again, especially in the legal drafting process. So I definitely think that there's valuable insights that can be gained from that. But again, you know, it's important to kind of manage expectations and not to think that lawyers can sort of replace the role of software developers in their entirety.
I think, Annelies, maybe because of your role of translating technological and legal, you also may have some views or some thoughts on this issue?
Yes. I hope I don't decrease my credibility, but I do have myself, I don't have any technical background, so I have no IT background, and now I am in a IT product owner role. So yeah, I really do believe, and I have to believe it, otherwise I wouldn't be here, that it's not the in-depth or the technical knowledge is not the key to the combination or to find a common language between both legal areas of expertise and the more technical or IT areas of expertise. But it's more to have somebody on the intersection maybe between these areas, to have like a full view on the bigger picture and to grasp the concepts more high level of both the legal challenges and both the IT challenges without diving too deep into these areas of expertise. So you will always need to have experts on the case, but I don't think that everybody has to be an expert in both legal in the legal area and in both the IT area. I think it would help to learn a bit from one another. For your concepts and to understand, like Senna said, okay, that's how an IT profile works and that's how a legal profile works to find the common ground. But I think that would be sufficient. And
okay, Mr. Sapp, if you want to add something, or
I fully agree with what was said by Senna.
if you,
it's an interesting combination. We have a legal group within the Federation, 40 lawyers and so on, and 100 ITers in the Federation, and it's really interesting to see how they battle, so I think it's stay on your own business more than to do a mix of the two of them in one person. I think the battle is interesting, and have good product owners is also very important, I think, to manage all this.
I agree with what has been said, and I think you don't need it. It depends on what you want to do. If you really want to make a startup like Mr. Mendes has, then you probably will need some more technical knowledge. For me, I learned a little bit of Python, and it helped me to see how software developers think.
Yeah.
And I won't write the program for you, but I can have a discussion with the programmer. And so in the beginning, that was a real eye opener, how a certain concept has a name, or a name has different concepts behind it. And if you're talking about something, bias, for instance, for a software developer is not necessarily a bad thing. It is just skewed. Whereas bias in the law is a lawful discrimination. So you have that and multiplied by 1,000. So it helps for that.
yes, and I can give some of us as well can give the academic side, where also, for example, CITIP is involved in a lot of projects which combine technical partners with social science partners, with legal partners, and it's really interesting to see that dynamic going in the project, to find a common language, to really learn from each other how to see a problem. So yes, I totally I would also agree from the academic point of view. Someone in the audience has a specific question?
Practical question, because I used to be a legal counsel, and one thing that was also frustrating was, for example, when in a civil law country communicate about in a common law country, you have to take into account the context into a contract. So in the beginning, we try to take into account the context clause. And I'm like curious how to do these situations.
Yeah, that's a very good question. So maybe to rephrase for the audience very quickly, I don't know if that question.
I think they heard it via now we put on the sound there, but feel free to rephrase it. Yeah, very short.
No,
yeah.
but if it's clear, then that's fine. So yeah, you ask about how we deal with the difference between civil law, common law, and things like that. We take very good care not to leave everything to AI. In a lot of different, software applications, or in a lot of different environments, there's this idea that AI is sort of a magical wand that can solve all problems. We know full well that AI is not quite up to that level yet, that it can comfortably understand things like the difference between civil law and common law, especially because the data isn't there to teach AI on that difference. So yes, we support clause-based with all manner of AI applications where it makes sense to do so. To give you an example, clause-based features a lot of in-depth grammar support. That's something where AI can make a real difference, like knowing how to conjugate certain verbs depending on certain words being phrased in a different way and things like that. That's where AI can make a difference, but not in that area where the difference has to be made to in the question of what is the applicable law. If the applicable law of a certain commercial contract, for example, is England and Wales, then we have that common law tradition, and clauses may need to vary a little bit. That's where the lawyer comes in. The lawyer explains to clause-based or creates these clauses in such a way that we can either switch between, let's say, the England and Wales variant of a clause and the Belgian law variant of a clause, for example, or that we can even build clauses that can adapt to that nuance within the same clause, so that a clause is just entirely portrayed differently depending on the applicable law. That's again that chameleon clause example that I gave. But the key thing here is that you need to be very careful on what are you outsourcing to the machine and what is still being done by the lawyer. Our goal has always been to create a tool where the legal creative work, where the legal expertise sits squarely within the realm of the lawyer, and everything else, all the production work, is outsourced to the machine. That's actually a very interesting concept that has been created by Jaap Bosman, who is a Dutch consultant on the legal sector in general, and he posits a difference in legal work between creation and production. And creation is the high-value legal work that's all about exercising legal creativity, finding creative solutions, leveraging expertise. That's the real value. That's what the client pays for, i.e. that knowledge between what is common law, what is civil law, how do those two interact, and production work, which is the battle with Microsoft Word, actually getting that idea, that wisdom down into a physical format of a contract, a deed, for example, right? A petition to the court or whatever. And currently, in the way that the practical legal service delivery is currently set up, a disproportionate amount of time is still being poured into that production work, whereas the value really lies with creation work. So our goal with clause-based has always been to reduce that production work, where also the lawyer doesn't really add any value. I mean, who goes to law school for 5 years and is then a Microsoft Word expert, right? That's not really what we're taught. So yeah, that's kind of our philosophical underpinning. And I think your example is a very good example of what we try to achieve, where we try to draw the line between this is the lawyer, this is the machine.
I think if I may just link it, because you think I bring in the lawyer, but more generally, what is the role of humans in this digital age? What is our added value still in this digital age? And you have clearly already mentioned several aspects, but maybe the other speakers could also what is the role of what is being human in a digital age? And I'm especially Geneviève, you can probably say a lot of these things because your PhD deals a bit with the role of judges, but
yeah, well, where to start? I think what Mr. Sapp already said, the human contact with the client is still important, so that is valuable for the court system as well. But as I've said, it depends on the circumstances and on what the needs are. And I think I have no formula that determines, okay, this will be done by the machine and this should be done by a human. This should be done by a human. I think before I would send somebody to prison, I want to have seen that person. I want to have heard that person. I'm even reluctant to only see somebody via a screen. But then I don't practice criminal law, so you should, talk to the judges.
The context again.
Yeah, context again. Juvenile court, I think a juvenile who's in trouble, be it an educational situation which is difficult, or being the juvenile who is derailing and who is showing behavior that could be qualified as criminal if it were an adult, I think should be seen by a human being. That doesn't mean that the juvenile judge could not be assisted for some things, and just to see, well, how are my other colleagues thinking about this? Have I captured every aspect of the problem? There could be some assistance, but in the end, the human intervention and the decision should remain human.
Yeah.
Invoices, tax law. The tax authorities in Belgium are very advanced in analyzing the cases they have, are more advanced in analyzing the cases than we have as judges. So this is also a type of law which is, verging on regulation and which is fixed, which is rule and systematized. So there you probably could go much further, which is probably a bit more production oriented than really. It's the creative aspect and it's the inherently human aspect. But how do you define that and how do you fix that? There's interpretation possible. It's value oriented.
Okay. If someone
that's a very important question, I think. What is really important for our sector, the notary, but I think for the lawyers also, is trust. And trust, I don't think you can replace that by digital, I don't know, by digitalization, and the contact between a client and a notary really is focused on that trust and analyze the complexity of every case. And these trust and analysis are two things on which you really need, I think, the human touch of somebody, and in this case, the notary. So,
but technology could also increase trust, no? It's often mentioned that we trust
important that
technology
that
more
trust,
than humans.
It's important that the clients, the citizens, do also have trust in the technology. That's really also for them on a trusted way that it can work. Otherwise, it won't work. It's again, it's between balance.
Yeah.
It's getting sometimes we're looking on this balance between technology and the human interface.
I actually have to concur here. What I've seen in practice is that, I wouldn't say lots of law firms, but there's definitely a growing contingent of law firms across Belgium, but really across the globe as well, that has been experimenting with, creating making automated legal services available in a sort of more open access format, or even in a sort of innovative service delivery. Think, for example, online web shops. Think self-service portals for document creation. That's something that we've been seeing in practice a lot of times. And there's much to be said for this new innovative way of service delivery. But ultimately, what we've seen is that indeed the trust emanates from the human. And so in a lot of different cases where those tools are successfully adopted, those tools that those law firms are putting out there and are using their own branding on, ultimately those are most successful when there is a kind of escape hatch from the automated, where the end user, the client, is given the option to actually talk to a human being at a certain point in time, and that may not change anything about the ultimate outcome, the ultimate product, a document that's being delivered via the platform, but the trust in that document and to engage with that platform in the first place, that emanates from the human.
Okay.
Yeah, in my experience also do AI for professionals, and trust is You cannot just say that the professional will trust the technology. You need to explain very, very explaining what you do. A common language is very hard to find here because data scientists are still very technical. They completely understand medical research workflow. We can win, but we still have a language. Same for business people, they also talk a language, and you have the end user. And when a salesperson is doing a sales pitch, he will again need another language. So it's a very hard work to bridge all those worlds. Trust is key, and explainability is for every participant in software development, for legal professionals, something else. And then going back to the beginning of the discussion where you said what can be done by humans and what can be done by machines. Yes, you need to choose what you rely to have machines and what by humans. What should be done by machines is such knowledge tools you need to feed the machines, to validate, to go through it, the engagement, implicit and explicit knowledge for humans is still crucial. You can never do it without it. And it's not that you finalize something today, you deliver it, and it's finished. No, it's technology advanced, but also the interaction with end users and subject matter experts and legal professionals.
So it's about different kind of intelligence, machine intelligence and human intelligence. And very happy to hear that humans will still play a role in the legal field. Yeah, yeah. No. Okay, no, that is.
Yes, never.
Yeah, totally. The concept of trust is very interesting that it's been touched upon, because I think that the pandemic actually showed that trust is indeed important technology, but also the difficulties to regulate technologies in Belgium because of the different layers we have. We have the Flemish government, we have the federal government, we have Brussels, we have, well, so how do you deal with these kind of, we talk about lawmaking policymakers, the law as an impediment on innovation, but what about the different levels within Belgium on technology and the implementation of legal tech? Yeah, it's you may think about
very
it,
practical. For us, it costs money.
Okay.
Because I know we have to make. We are a federal organization. We work for the Brussels notaries, the Flemish notaries, and the Walloon notaries. Instead of one application we had when the law was a federal law, now we have to make 3 applications for the Brussels, the Flemish, and the Walloon notaries. So it costs. It's a bit practical, but it costs some money, a lot of money for us, because we have to have 3 different applications. We have to develop 3 different applications nowadays. It's not really easy to handle this.
Yeah, but it's an interesting answer actually. It costs money. I would not. Yeah, no, that's it makes sense. It makes sense. If someone wants to add from
Flemish government.
Yeah, from the Flemish government, for example.
Maybe a message of hope. No,
Yeah.
I do think everybody knows all the Kafka situations in Belgium. But if you look at the Corona crisis, and if you look at the vaccine invitations that had to be sent and the Corona Safe app, then we saw that when the need was very urgent and everybody was aligned, okay, this purpose is a good purpose and we need to serve this purpose, that a lot can be, a lot can happen and a lot can be made possible. So I'm not always, I don't know if it's about not being able to do things like that, but more like, is everybody aligned on the benefits of what's at stake? And for example, with the Corona crisis, it was very clear that everybody would benefit from some uniform system there, and that one party would be in charge there to disseminate all these certificates and invitations. So that's maybe something I would like to add on this discussion.
Also, because we worked on we had contacts with the Flemish government as well on something else, on mobility as well, and there was also mentioned that actually when there's a will to cooperate, it all works. It's just about the fact that we have different levels is not by itself a problem. It's more about like the right mindset needs to be there, and indeed the pandemic showed that in situations of crisis a lot can be done. So it may be true. I don't know if someone wants to contribute or add something or. on the levels. What are actually other, when we look at the implementation of legal tech, we already discussed a lot of challenges, but what are the challenges, but also what would be the benefits to society at large to have legal tech on a large scale, for example? What would be the societal benefits to have it implemented and to have it really workable, let's say?
I think the key overarching goal should always be access to justice. Should always be, improving legal service delivery to clients. There are indeed quite a few obstacles to legal tech implementation on that front. I think there's legal obstacles in the sense that any kind of technology definitely any kind of technological initiative that's undertaken definitely needs to take into account a bunch of very key measures, like for example GDPR. I'm hearing FedNot engaging in wide-scale anonymization of existing content. And that's of course important. The last thing that you want is to take that data that contains all sorts of personal information, right? Notarial deeds. Doesn't take a genius to figure out that there's quite a bit of sensitive data included in there. It's important to start with clean data on that front. So I think GDPR especially is one. Also, given my own background as an IT lawyer, is something that definitely pops up. As for practical obstacles when it comes to access to justice, right? There's we've talked about this earlier. We want to do this in as inclusive a way as possible. Any sort of technological initiatives designed to improve access to justice, and so it cannot be hinged on an advanced level of digital, being like a digital native, for example. It cannot be hinged on everyone having advanced knowledge of how a smartphone works and things like that, because we know that in practice not everyone has that kind of knowledge. So that's some insights from my angle.
Okay, thank you. Very interesting. If I will let people think a bit, for more like for a legal tech startup company. Suppose I'm very enthusiastic. I want to create my own company. What would be your advice to a young startup company in this legal landscape? How to have this unique selling point, and what is still missing, let's say, because a lot of things are going on. What is missing?
I'm assuming that.
Well, no,
what's still missing? I think it's a very fragmented landscape out there. There are quite a bit of companies engaging in legal tech or in adjacent fields that kind of border on the legal tech. It's important to have a very extensive knowledge of how the process works and how the legal sector currently stumbles in the execution of its service delivery and things like that, and to always kind of start from the way that things are actually done and how those are problematic. Like I said earlier, there are plenty of solutions out there that are solutions in search of a problem. Those typically don't tend to last too long because there's just no fertile land to build on for a solution like that. So if I could distill my advice to you, Jan, for your ambitions to start a company, down to one sense, it's talk to the people who would be using these services, and find out what makes them tick, find out what problems they run into.
Okay, and just off the record, I will not start my own company, so that is not the reason why we invited you to get free advice, so no worries. If someone wants to, if there are still questions from the audience, go ahead, also online. If I may ask you, because I also talk with the judge but more on liability aspects, and I know it's not your expertise, but as you know, we have the AI Act that is now being adopted at the EU level. But when it comes to private liability, it is still very much national law, fault-based liability, very national. So there's diversity. So even if you have at the EU level the aim to harmonize, eventually rule making will still be very national. It's been talked about civil law, common law. How do you, technology aims to be universal, let's say global, but lawmaking, especially in private law and liability law, is still very national. How do you reduce this risk of diversity between member states, for example? Is there some key takeaways in this regard, or?
I think you're probably the best qualified to answer your
Well,
question.
no, I have my thoughts, but I find it interesting to have a judge perspective. If you do not have an answer, it's no problem, but maybe you have some views as well on this, how to really, is it possible to harmonize, for example, AI and the regulation of AI? It's not really legal tech, but is it possible to harmonize? Do we need uniform EU legislation on technology, for example, or?
You could set a few standards, but then again, standards are context dependent. And I think the idea of harmonization is important. And at the same, it's another balancing act, I think. But it is not my field of expertise, so I gladly.
The expertise we have, we work together with on the European. We have an European Notary Federation, and as I see differences in regulations and responsibilities between the different EU member states for the notary sector, it's really very difficult to go on a quick basis to harmonization. I think, like you said, some guidelines, some standards on the EU level, some important principles on which we can, on which are important for the EU. I think we have to focus, or they have to focus on that level, not on a national level. It's, for the moment, it's not really realistic to focus on a big harmonization.
Yeah, okay, yes, it's a bit my view as well. So I'm very happy to see it falsified by several other experts. I don't know if there are some other questions from the audience. If not, I'm gladly giving you the final word to our speakers, so fantastic speakers. And I would say, please, in 1 minute, your key takeaway on legal tech. What is the story? What would be your key takeaways to the world when it comes to legal tech? And Annelies, you can start, or so if someone has already some clear ideas, or just 1 minute pitch takeaway.
I have no clear ideas, but to be in line with what I said earlier and my message of hope and that everything is possible, maybe a takeaway from me would be that we don't have to be scared to get into the field of legal tech or get into the field of IT. If it's new to us, I know that the Administrator General of Digital Flanders, Barbara van den Houten, has also a law background and is now head of Digital Flanders. And she once stated that for her, it was an advantage that without any preconceived knowledge, she was able to ask a lot of questions, like with a blank page, not blank because she has a lot of knowledge, of course, on other topics, but that it could help to have somebody sitting at the table that doesn't have this in-depth knowledge and just like common sense and some common concepts, and that is sufficient to have some useful input on this topic.
Okay, I think it's a nice message of hope. So great, Senna.
Yeah, I think there's been quite a few topics that we discussed today, so it's hard to boil everything down into one sentence. But I would have to agree with Annelies that the message should be not to be scared of technology, of course, and in general, I think in private practice, and I think we're well underway there, but there could be more done towards that goal. But I think there should be more openness towards experimentation, and to set up small initiatives without that focus on large scale stuff that if it fails or if it doesn't fail, but if it fails, that essentially sours the experience, right? I think there should be more willingness to see what's out there, try it out, and of course taking into account all of the necessary limits that we do have to impose there, but in general, a more open approach towards legal tech implementation and adoption is something to be encouraged.
Okay, wonderful message as well. Mr. Zapp.
Well, we as a notary sector, we keep on investing investigating on legal tech and try to work together with legal tech companies and or other sectors on digitalization. For us, the key will be finding a good balance between the human touch and the IT, the technical touch, and that we will see in the future what that will give. But that balance it's key for the notary sector.
Okay, thank you. And last but not least,
I would say that legal tech in general, machine learning and NLP systems more particularly, are not inevitable and are not, there's no other way you can go. That is not the case. It is a balancing act. At the same time, this is how society is evolving. And I think the judiciary is part, if it wants to stay part of society and if it wants to stay relevant, has to be in tune with society and find that balancing, cooperate in finding that balancing act. It is how the intertwinement between human and machine is effectuated and who is affected and how are people affected, who is left out. That are important questions that the judiciary, in creating the systems, together with the private sector, needs to be thinking about and needs to be aware about. And that's what I want to take away.
Thank you very much for this nice key takeaway. So I heard balancing the role of humans remains important, and we welcome legal tech. I would like to thank our fantastic 4 speakers. We have a little kind present. It is not related to technology. It is related to food, which is of course always good. We have some gadgets. We'll give them to you in a moment. I would like to thank the audience online to join us. I would like to thank the participants here to join us. I would like to thank my fantastic team to having organized this this data day. So thank you as well. And we hope to see you at the next event of the Knowledge Center. Please check our website and enjoy the sun and the rest of the day. Thank you very much.